Mr. Scott, it appears that you and Miss Kusich either are or were in a relationship. While you don't live together and never have, you confirmed that you did date. Both Miss Kusich and Miss Goen are employees at DSHS, as are you, with over 30 years of service. When asked about your supervisory relationship, you explained that you work for the office of the secretary. Miss Goen is the administrative assistant to your boss, who is the second in command of the entire department. Lisa Yanagita is also involved on the same team. The issue lies in the fact that, according to the administrative policy you attached, Miss Goen has violated workplace guidelines. This forms part of the basis for a potential lawsuit you are preparing to file. You shared images showing memes and messages that Miss Goen circulated in the office, one of which includes a caption where she says, "Dude, I would normally message a coworker, but I can't stop laughing, so here it is." Given her role as admin assistant to such a high-ranking official, this behavior has created a difficult work environment for you, one that undermines trust and professionalism. She also made comments about being on a dating site just for kicks despite being in a relationship, and shared inappropriate memes that you believe constitute workplace discrimination and misconduct. Because of the seriousness of these actions and her likely violation of the administrative policy, you believe she could lose her job, and you are seeking protection and recourse through legal means. Clip 2. Your Honor, I am the Senior Administrative Officer at DSHS.
You and Ms. Krusich either are or were in a relationship?
Dated. We don't live together. Never have lived together.
But you dated?
A little bit. Yes, Your Honor.
And both she and Ms. Gogan work at DSHS?
Correct, Your Honor.
Okay, as do you?
Yes, 30 years.
Okay. And are you in their supervisory chain of command?
Can I explain that to you, Your Honor? So, I work for the Office of the Secretary. Mrs. Gogan, she's administrative assistant for our boss, who is the second in command of the whole department. Lisa Yanagita is the chief of staff. Okay. So that's where part of and where the problem lies, is that per our administrative policy that I think I attached there for you to look at, she's violated that. And as I move forward and present a lawsuit and everything else, because in this, in some of the photos I sent you, she sent these memes and information around to the office. And if you see the one that I sent you, where it says in there, do you see who's on there? And I'm a coworker, where she says, "Dude, I wouldn't normally message a coworker, but I can't stop laughing." So here it is in this office where you're the admin assistant to the second highest person in our administration. And now how am I supposed to work with you every day and trust when you're discriminating and doing all these acts of inappropriate behavior in the workplace? And so part of my action is I'm probably going to file a lawsuit against her. And so I need that protection for me, because per our policy, this administrative policy, she's probably going to lose her job because of that. She even the words that she uses, where she knows what she's doing is right. I wouldn't normally message a coworker, but I can't stop laughing. And then even looking at this, she talks about how she's in this picture with her boyfriend, but she's on this single dating site just for kicks. And then the meme that she puts in there, where and she makes a comment and she's laughing her head off.
Third in line from my direct supervisor. I have been with the department for 30 years. I hold an MBA, a background in health management, HMS, and a Six Sigma certification. I also served in the U.S. Army for 20 years and currently own my own business. The actions in question have significantly impacted me both professionally and personally, and once my lawsuit is filed, I anticipate further complications. Regarding Ms. Goen, if you refer to our administrative policy, specifically item number 3, it clearly outlines that violations are not limited to in-person conduct but include behavior via phone, email, text, social media, and electronic communication, even outside of work hours. Her conduct falls within those violations. As for Ms. Hogan, The concern is her online activity related to the workplace. In addition, I currently have a motion pending with the Washington State Attorney General's office involving a Facebook-based group called Are We Dating Him Too? This site posts photos of individuals, mostly men, without their consent, including mine. Women, often anonymous, can post disparaging or slanderous content. There's no accountability, and it creates serious reputational risks, particularly in my role. Someone like Miss Goen, who may be participating for fun while in a relationship, can still post whatever they like without consequence. This behavior is defamatory and deeply concerning. Regarding Miss Kusich, after I ended our relationship, she made a series of anonymous online posts implying misconduct on my part. I have submitted the related images. From the photos, it's evident the interaction was consensual and amicable at the time. However, she later identified me by name and workplace on the same defamatory website. This crosses serious lines of slander and libel. In addition to my role at DSHS and the Army Reserves, I am also a voting member of the Behavioral Health Resources (BHR) board in Olympia, a highly competitive and respected position. Miss Kusich is familiar with several individuals in that circle, and her public mischaracterized jeopardized that hard-earned role. Clip 3. Your Honor, I understand that this may not be the proper process to achieve the outcome I'm looking for. I recognize
Senior administrative officer there. I'm third from my boss in the department. I've been working for DSHS for 30 years, Your Honor. I've attained my MBA. I have a HRMS background. I have a Sigma Spleen. I've been in the Army 20 years. Currently, I own my own business. All these things that she's doing affect me greatly. And it's an issue and it's a concern. And once that lawsuit drops, it's going to be a problem. So that's the Gogan thing. And then if you look at the administrative policy on number 3, actions that violate this policy aren't limited. Violations via phone, email, text, social media, electronic communication. Such behavior can also be outside of work. It specifically speaks to this in our administrative policy.
So as to Ms. Gogan, your concern is about her posting something online.
Well, in the workplace. So,
okay, and what about Ms.
So let me finish this. Please, let me finish Ms. Gogan.
Well,
So I also have currently the Washington State Attorney General's office. I have a motion in with them because these folks are putting photos online without the permission of
who's doing it?
Are We Dating Him Too? It's a site that's it's a group that's embedded into Facebook. And currently I have with this Attorney General's to take that website down because they are putting males photos up without their permission, and they are women who are on there that are anonymous. So you don't know who it is. It could be any bandwagon person like Ms. Gogan, who's in a dating relationship, who jumps on there for giggles and can post anything she wants. It's libel and it's slanderous. And here I work with this person, and you're going onto a website like that where it's very, very libel and slander. So I'm working on doing that for that website. Mrs. Krusich, she was upset that I stopped dating her, and I sent her home one night. And then here, when you're looking at a couple of those, her first posting, she tried to be anonymous and said that this guy was trying to get me to go to work or to blah blah blah, and I sent the photos on there. It didn't look like I tried too hard to get her there. She looked pretty happy there. And then currently, not only does she work for DSHS, but she also has a few things of mine, and she's saying things that are disparaging on that website. And now she has her name on there, and she's identified me where I work, which is very slanderous. I'm currently in my position. I'm in the Army Reserves. I'm also a voting member for BHR in Olympia. And she knows several of those folks. So here it is, you're saying slanderous and libel things, and I could lose that spot, which is a very coveted position for me to be on a voting board here in Olympia. It took me a long time to get that position.
Your Honor, I understand that this may not be the proper process to achieve the outcome I'm looking for. I recognize that protection orders are not meant to stop people from saying negative or even false things about others, as they are protected under the First Amendment. I know you hear this often. People come in saying others are calling them slanderous names online, spreading misinformation, and damaging reputations, and I understand that, under this process, there's little that can be done unless it meets specific legal criteria. In my case, this is happening in the workplace, which is especially difficult, and my concern is not just personal but professional. I believe the individuals involved are violating DSHS policies, and while DSHS may have grounds to take disciplinary action, termination, suspension, or revoking access to work resources, that's something the agency would have to address internally. If, after disciplinary action, someone begins to harass or threaten me, then I understand that might rise to the level of a protection order. But for now, it seems their actions fall into the realm of speech, however inappropriate or damaging. I also understand that civil litigation may be the more appropriate route to address the reputational harm I've suffered. While I won't be receiving a remedy through this process, I want the court to know that I'm pursuing every available avenue. For me, this is about exhausting all legal and procedural options. It's one step in a broader process, not an end in itself. What's most frustrating is that I know other individuals, particularly other Black men in professional settings, who are facing similar public targeting through social media or anonymous websites. I also believe there may be legal grounds under Washington state's two-party consent laws that could apply to some of this conduct. I haven't fully explored that yet, but I intend to. I'm persistent, Your Honor, and I will continue pursuing appropriate action through every legal channel available.
Internet? I don't think this is the process for you to achieve what you want to achieve. Because one of the things we don't do with the protection order process is keep people from saying bad things about other people. It's their First Amendment right. And so I get this all the time from people who say, you wouldn't believe what they say about me. None of it's true. And they post it on social media. They broadcast it to the world. They call me a pedophile. They call me this. They call me that. And we say, sorry, we can't do anything about that.
I agree with that, Your Honor.
So
I
don't know how I can do something about this.
For me, it's work. I have to.
Right.
Ms. Goldman can't come.
No, I understand your position. This is, you don't like it, and things should happen at work because she's violating work policy and so on and so forth.
So what if something happens,
So
Your Honor?
We can't do something proactively here. We can only do something if it meets the statutory requirements. So if she gets fired because you complain about her, whatever she posts about you, and she gets fired because she's violating the DSHS policy, which sounds like that potentially could happen. Then if she starts calling you and threatening you, then we can give you a protection order. But right now, you're just saying she's going online and telling the world that you are whatever she is, she's laughing at you or whatever she's doing. And the same for Ms. Krusich. I don't know if I'm pronouncing it. Yeah, and same for Ms. Krusich. They have the ability to do and say that. I can't tell them to stop. DSHS can. They can say you're violating our agency policy, and for doing so, here's the sanction, whether it's whatever it is, firing or loss of pay, or give up your computer or whatever.
Right.
They can deal with that. I can't. This is not the appropriate procedure. You can file civil lawsuits against them for the damage
that's coming. Yeah,
that's you feel has been caused to you, and your harm of your reputation and those things. Those are actionable potentially with a lawsuit, but this process isn't meant to address them. So you're not going to get any, what we would call a remedy out of this. I can't give you anything that will address it. So, I'm just going to enter denial orders on these and not send them for a hearing. For that reason, I'm not, and I want to be clear, I'm not saying that what you're having to deal with is too small for this or anything. It's just this is not the appropriate process for that.
Oh, that's fair. For me, it's about exhausting all my needs.
Yeah.
So
no,
it's not not an end all for me. It's just another bullet in the process for me.
Yep, I get it. Certainly be frustrating to have a situation like that.
No, the frustrating part is that there are other males that I know that are Black males that are like me that have been dealing with this on these websites, and that's, I'm not sure. I think there's a point in there where Washington State is a two-party consent state. I just haven't dug it deep enough, but I believe I've seen that in there. But I'll find it. I will.
Okay.
I'm persistent, Your Honor.
Yeah. On the morning docket, Kareem Williams' case was continued from the previous week because he was unable to make it to Panama City. Mr. Williams was offered a pre-trial intervention, which had been supplied to him, but his intentions regarding the offer were unclear. The judge explained that pre-trial intervention is an agreement with the state, supervised by probation and parole, which allows the case to be dismissed if all conditions are successfully completed. It's similar to probation but not officially considered probation. Mr. Williams said he spoke with his public defender, who provided the terms, but he did not agree with them. When asked to clarify, he admitted he didn't fully understand. The judge reiterated that if Mr. Williams completed all required terms, the charges would be dropped. Mr. Williams asked to pose a few questions, and the judge advised that his lawyer, sitting next to him, could better assist with follow-ups. Mr. Williams said their communications were limited due to time zone differences, with scheduled phone calls missed or delayed. The judge emphasized that the pre-trial intervention was a highly favorable offer and that he could either accept it or proceed to trial. Mr. Williams said he didn't want to go to trial, prompting the judge to state that his lawyer had done everything he could. Mr. Williams then asked whether the charges were brought by a specific party, believing there was an injured party involved. The judge clarified that only the state can bring criminal charges, not individual victims. They can only make complaints. The charges included possession of a controlled substance, providing a false name, and resisting an officer without violence. The court then scheduled the trial for June 2 at 8:30 a.m., with a trial management hearing on May 23 at 1:30 p.m. The judge advised Mr. Williams that if he changed his mind, he should speak with his attorney, who is on Central Time, while Mr. Williams is on Eastern Time. The judge noted that simply adjusting the time by 1 hour could be all it takes to get the charges dropped without going to trial. The next hearing involved a sovereign citizen who identified herself as House of Jennifer, a variation of the family of naming used in such ideology. The case number was 236-5992, ALBNB Funding LLC versus Jennifer. The matter was before the court for a motion to set aside a default judgment filed on January 29. Attorney Richard Bruin, bar number 35222, appeared on behalf of the plaintiff. Jennifer joined via Zoom and explained that she first contacted ALBNB Funding after checking her credit score. She said they had been sending documents to the wrong address. Citing 15 U.S.C. Section 1692, she said she requested debt validation, payment history, a signed contract, information about any insurance claims filed, and the title chain of the debt. She claimed none of that was provided. At the time, she was caring for her mother, who had pancreatic cancer, working as a central essential worker, and raising 2 disabled children. As a result, she said she did not receive court notices. She added that ALBNB told her the account had been transferred to a company called MIDI, with whom she resolved the issue. However, she said ALBNB still failed to provide required documentation. Jennifer apologized.
Basically supervised by the probation and parole, and then the case is dismissed if you successfully complete the term. Pre-trial intervention is a program that's offered by the state, and it's supervised by the Florida Department of Corrections. It's like probation, but it's not probation. It's an agreement that if you successfully complete the pre-trial intervention, the state drops the charges against you.
Well, I spoke with my public defender, and he gave me the terms and the things that I have to do, and I didn't agree with him.
Okay.
And I don't understand.
Sir?
I don't understand. So, like, the charges will be dropped.
If you successfully...
If you did all those terms.
You have to abide by those terms and conditions, and the case would be...
Mr. Bruin, counsel for the plaintiff ALBNB Funding, responded to the defendant's motion by clarifying his involvement in the case. He stated that he has been retained as counsel since November 2023 and reviewed his file and electronic notes going back to October 2024. He noted that a default judgment was entered on June 12, 2024, based on personal service of the summons and complaint. According to his records, the first time the defendant contacted his office was on December 5, 2024. Under the Fair Debt Collection Practices Act, FDCPA, 15 U.S.C. Section 1692, debt validation requests must be made within 30 days of the initial demand. However, by the time the defendant reached out, that window had passed and the judgment had already been entered. Mr. Bruin further noted that the defendant filed an objection to a wage garnishment in December 2024, which was heard on January 8, 2025. At that hearing, the defendant claimed the debt belonged to Midland Funding, with whom she claimed to have settled. The court clarified then that she was attempting to challenge the underlying judgment. The balance at that time was provided to the defendant. As of now, Mr. Bruin stated that only $89 remains statutorily owed and he is prepared to file a satisfaction of judgment. He mentioned that the last hearing on record was adjourned to the present date, and the matter has essentially been resolved through garnishment. Due to audio issues, the judge asked for clarification, noting that the device connection had caused some of Mr. Bruin's final comments to cut out. Mr. Bruin reiterated that less than $100 remains and he intends to file satisfaction of judgment. The judge then inquired whether Mr. Bruin had seen any documentation indicating the debt was paid through Midland Funding. Mr. Bruin confirmed that this case never involved Midland Funding and that his office does not represent them. He emphasized that this was a direct, one-time assignment from Credit One Bank to ALBNB Funding. Midland Funding was never part of the chain of custody. With that, Mr. Bruin concluded his remarks.
Several phone conferences that were scheduled.
Yeah, we missed a lot due to the time difference.
Sir?
I said, but we missed a lot due to the time difference.
He was on Eastern time and he would call an hour late.
I mean, a pretrial intervention is about as good as it gets. If you can take it or not take it, are we ready to set it for trial?
Yes, sir.
Well, then Mr. Meredith has done exactly what he's supposed to do for you. He's got the very best deal worked out for you. If you abide by the terms and conditions of the pretrial intervention, the state will dismiss the charges.
So the charges are brought upon me are by the state?
Well, who do you think brought them?
I thought I had a party.
Huh?
I thought it was an injured party.
The injured party, aren't they dope cases?
What is the jurisdiction of it? Is it criminal or
I
civil?
don't think you're near as smart as you think you are.
I'm just asking questions.
Yeah, you're not. Your possession of a controlled substance, giving false name, causing adverse effect. I guess there could be a victim on that. And resisting officer without violence. So, I don't know anything about the case, but it looks like you might have got a false, gave somebody else's name.
You just told me that the state was the.
The state's the only person who can charge you. Nobody else can charge you. It's the state. The victims can't charge you. They're just the alleged victims. They can't charge you. They can't do anything except make a complaint. But you've got offered a pretrial intervention. If you do the pretrial intervention, the state will drop the charges against you. If you don't meet the pretrial intervention, you come back to court and you start your defense again.
I don't wish to argue the facts.
Let's set it for trial.
Yes, sir.
Let's set it for May 5th at 8. Let's set it for June. What was that June date? June 2nd at 8:30. And it will be May 23rd at 1:30 for trial management. And if you change your mind and want to enter the pretrial intervention, you probably need to discuss that with Mr. Meredith. But remember, he's on Eastern Standard Time. Okay?
Thank you, Your Honor. I agree with your earlier point, and I'd like to clarify that I did reach out to the original creditors. That's why we are here today. My understanding, based on those conversations, is that my account was transferred to Midland, and that is where the account currently resides. Now, I recognize that how assignments are handled between collectors is not my area of expertise or profession. However, to my knowledge, that debt was transferred, and as far as this particular debt is concerned, my wages have been garnished. Therefore, it has been paid in full. There is no remaining balance of $89, as that amount has already been deducted from my pay. Moving forward, I respectfully request, again, for the record, that I be provided with the debt validation information I've been asking for. This includes the full payment history, a copy of the original contract bearing my signature, and confirmation of whether any insurance claim was filed related to this account. These are my rights, and I believe ALBNB funding should provide this documentation, even now that the debt has been satisfied. I would appreciate having these materials for my records. Clip 7. All right. Thank you. The central issue addressed by the motion in this
did call LVMV funding when I checked my credit score, and that's how they were able to reach out to me. They were sending information to a different address, and according to Site 15 USCA 1692-, I asked for a debt validation. I asked for the payment of history. I asked for a signature of contract with me and the creditor. I also asked for if there was any insurance claim filed, as well as the title of chain of this contract. And I didn't receive any answer. Next thing I know, my mom was dealing with pancreatic cancer. I'm an essential worker. I have 2 disabled kids. So when they were sending out these motions and so on, I was unable to receive them because I wasn't getting any mail, so on. So, and I reached out to the creditor, and they said that they gave my account to Midland. I have since resolved the issue with Midland, and it is paid. I then reached out to LV. They failed to give me all my information document needed, and now we're here. So I apologize for not appearing in court when I was going through my difficult times in life, but I am here now.
All right. Thank you. The central issue addressed by the motion in this matter is a request to set aside a judgment previously entered by default. In order to grant such a motion, the court must find both good cause and a meritorious defense. I have reviewed the motion and listened carefully to the arguments presented. While illness may be sufficient to establish good cause, that alone is not enough. There must also be a showing of a valid, substantive defense to the original claim. In this case, I do not see any meritorious defense asserted in the motion or supported by affidavit. Arguments related to seeking debt validation or other documentation prior to the entry of judgment are not relevant to whether the default judgment should be set aside. The legal standard is clear, and the requirements have not been met. For that reason, I do not find a sufficient basis to set aside the judgment, and the motion is therefore denied. That said, it does appear that the defendant is entitled to a satisfaction of judgment at this point, and that should be forthcoming from the plaintiff. If it is not, the defendant may submit an application for satisfaction directly to the court. I did note that the document submitted with the motion addressed satisfaction of a separate judgment involving Midland, which is not the plaintiff in this case and is therefore not relevant here. That concludes my ruling. This matter appears to be at its end, and I look forward to receiving the appropriate satisfaction of judgment to formally close the case. I wish both parties well. Good day.
And, again, under 1692 of the act that she's citing, validation of debt notices go out within the first 30 days of the initial demand. Defendant was way beyond that period. Judgment was already taken against her. And so if the case continued, I can see that she filed an objection to the wage garnishment in this matter back in December of 24, and then the matter was argued on January 8th.
There was something presented with the motion that was not in the form that is required post satisfaction of the judgment. That was a form addressing the satisfaction of a judgment in relationship to Midland, and Midland is not the plaintiff before this court. So that's my determination. The motion is denied. Again, it seems that this is at the end of the road, and I look forward to receiving a satisfaction judgment to close this out. I do wish both sides well. Good day to you.